Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 section 56 to 65.
Today, we're diving into a very important topic, Section 56 of the new Bharatiya Sakshya Adhiniyam 2023. This section is the absolute foundation for understanding documentary evidence, making it super crucial for your judiciary and APO exams. So let's get right into it. Here's a quick look at our roadmap for today. We'll start with the basics of Section 56, then break down its key parts, look at some real case law, see how it compares to the old law, and finally wrap up with why this matters so much for your exams. All right, first up, the introduction. Think of Section 56 as the main entrance, or the gateway to the world of documentary evidence. It sets the very first rule for how you prove a document's contents in court. Now, this section falls under Chapter 5, which, as you can see, is all about documentary evidence. So anytime there's a dispute over what a document, like a contract, a will, or even a sale deed, actually says, this is the section that kicks in. It tells the court how to find out the truth. The rule itself is actually very simple and straightforward. The Bare Act says it right here. You can prove what's inside a document in one of two ways, either with primary evidence or with secondary evidence. So what on earth do these two terms actually mean? Let's find out. The entire idea of Section 56 really stands on these two pillars, primary and secondary evidence. Getting the difference between these two is absolutely key to mastering this topic. Primary evidence, well, just as the name suggests, is the original document itself, the real deal. When you produce the actual signed contract or the original sale deed right there in front of the judge for inspection, that's primary evidence. And you know what? The law considers this the best evidence because there's very little chance of any error or fraud. And then we have secondary evidence. This is basically a substitute for the original. It could be a certified copy, a photocopy, or sometimes even someone testifying about what the document said. But, and this is a really important but, you can only use secondary evidence if you have a very good, legally valid reason for not being able to show the original. It's the exception, not the rule. So the whole process follows a very logical flow. First, you establish that a document exists. Second, you need to prove what's written in it. The general rule says, bring the original. That's your primary evidence. The exception says, okay, if you really can't bring the original for a valid reason, you may be allowed to use secondary evidence. Simple as that. Now, this whole system is built upon a famous legal principle called the best evidence rule. Let's take a moment to understand why the law is so obsessed with the original document. This rule is the why behind the hierarchy of primary over secondary evidence. You know, this old Latin maxim, verba volant scriptum monet, sums it up perfectly. It means spoken words fly away, but written words remain. Think about it. People can forget what was said, they can misremember, and copies can have mistakes. But the original written document, that's the most reliable, tangible proof you can get. Let's make this crystal clear with an example. Imagine A and B are fighting over a contract. A says the payment was for 10,000 rupees, but B swears it was only 5,000. What will the court do? It won't just listen to them argue. The judge will say, show me the original signed contract. That's the best evidence rule in action right there. Okay, so we've covered the theory. Now, let's see how this plays out in actual courtrooms. Looking at how the Supreme Court has interpreted this rule is super important, especially when you're writing answers for your mains exam. A huge case you absolutely need to know is Rup Kumar versus Mohan Thedani. The Supreme Court's statement here was so powerful and clear. The court said that once you've put the terms down in writing, that document becomes its own best proof. You have to produce the document itself to prove what's in it. This table here gives you a nice summary. Rup Kumar set the foundation. Then, in H. Siddiqui, the court made it even stricter, saying the conditions for allowing secondary evidence must be followed to the letter. And in J. Yashoda, the court added that if you want to use secondary evidence, you better have a good, proper explanation for why you don't have the original. All right, I know the question on everyone's mind is, how is this new law different from the old one? It's a great question, and let's clear up any confusion right now. Take a look at this table. It's actually very simple. What used to be Section 61 of the old Indian Evidence Act is now Section 56 of the Bharatiya Sakshya Adhiniyam. And the most important part? The core principle, the best evidence rule, has not changed one bit. So the big takeaway here is no major change in the law itself, just a new section number to remember. And finally, let's talk about the most practical part for all of you, how this topic shows up in your exams and what you really need to know. For your prelims, be ready for direct questions. They might ask for the section number or the basic rule. For your mains, it gets a bit more applied. A short note on the best evidence rule is a classic question. And you can definitely expect a problem-based question, where they give you a scenario and ask you to decide if secondary evidence should be allowed. So, for a quick recap, just lock these 3 points in your mind. 1, the section is 56. 2, the main idea is you prove documents with the original, and copies are only for special cases. And 3, its exam importance is very, very high. This is a concept you just can't skip. And that wraps up our deep dive into Section 56. I really hope this session was clear and helps you in your preparation. For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
If you're preparing for your judiciary exams, you already know just how critical evidence law is. Today, we're going to tackle a section that's seen some really important updates, Section 57 of the new Bharatiya Sakshya Adhiniyam, which deals with primary evidence. So let's dive right in. We're discussing Section 57 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about the core concept of primary evidence. And trust me, it's an incredibly important topic for both your judiciary and APO exams. So, what's our plan for today? Here's the roadmap. We'll kick things off with the most fundamental question. What is primary evidence really? Then, we're going to dissect the section's different parts, see how it fits into our modern digital world, and of course, look at how the Supreme Court has interpreted these ideas over the years. We'll also do a quick comparison between the new and the old laws, and I'll wrap everything up with some specific tips to help you master this for your exams. Okay, so first things first. What exactly is primary evidence? You can think of it as the gold standard for any documentary proof. The core idea is actually quite simple. If you want to prove what a document says, you can't just bring a photocopy or talk about it. No, you have to present the original document itself. This is the absolute foundation, the bedrock of how we prove documents in a court of law.
You know, the language of the Bare Act itself is beautifully direct. It says primary evidence means the document itself produced for the inspection of the court. In simple terms, this just means the original thing. Whether it's an original contract, an original sale deed, or whatever the document is, that's what has to be physically presented to the court.
But as you'd expect, the law is rarely that simple. Section 57 goes way beyond this basic definition. It actually includes several very important explanations that deal with more complex, real-world situations. So to really get a grip on this law, we need to break down these essential ingredients one by one. Now this is where it gets really fascinating, because you can see how the law tries to anticipate real-life scenarios. The first point is straightforward, right? You need the original. But then look at several parts. This means if a single contract is made in, say, 3 distinct parts, each one of those parts is considered an original piece of primary evidence. Then you have counterparts. Think about a lease agreement where the landlord and the tenant each have a copy. The copy signed by the tenant is primary evidence against the tenant, and the one signed by the landlord is primary evidence against the landlord. The last point, about a uniform process, is best explained with an example.
And you know, it's really helpful to understand this idea of a uniform process. The Act itself provides us with a classic illustration. It's about printed placards. Let's walk through this little legal hypothetical together.
So here's the crucial point. Pay close attention. Imagine 100 identical posters are printed from a single design plate. Now, if you want to prove what poster number 50 says, you can actually produce poster number 10. Why? Well, because they were all created through the same uniform process. They're identical. But, and this is the key distinction you must remember, none of those 100 posters can be used as primary evidence to prove what was on the original printing plate. That plate is a separate document, and in that context, the posters are just copies of it.
All right, now we get to what is probably the most significant update in the new law. The Bharatiya Sakshya Adhiniyam 2023 really brings the concept of primary evidence into the 21st century. It does this by adding detailed explanations specifically for electronic and digital records. This is a real game changer.
This is where the new law truly takes a modern leap. It clarifies that if an electronic record is stored in multiple files at the same time, let's say on a cloud server and your local hard drive, each of those files is considered primary evidence. It also recognizes an undisputed electronic record that comes from proper custody as primary evidence. For videos, if a broadcast is recorded and stored in multiple places simultaneously, each version is primary evidence. And what's really crucial is that the law now even acknowledges that automatically generated temporary files can qualify as primary evidence. Think about that. Of course, as any good law student knows, a statute is only one part of the story. We also need to understand how the courts interpret it. And while Section 57 is new, the principles that governing electronic evidence have been shaped by the Supreme Court for years through several landmark judgments. These cases give us some really crucial context.
For example, in the famous case of Anwar PV versus Bashir, the court laid down very strict certification requirements to make sure electronic evidence isn't tampered with. Then, the Tommaso Bruno case affirmed that direct electronic evidence, like CCTV footage, can absolutely be treated as primary evidence. And more recently, Arjun Pantitrao hammered home the point that the proper legal procedure has to be followed to guarantee the authenticity of e-records. These precedents on authenticity and reliability will no doubt guide how courts apply the new Section 57.
You know, this whole concept is rooted in a fundamental legal principle, the best evidence rule. This rule is simple but powerful. It says that a court must be presented with the best, most reliable evidence that exists. Section 57, with its strong insistence on producing the document itself, is a direct legislative application of this very rule. It's all about preventing reliance on potentially faulty copies when the original is available.
Okay, exam alert. For your exams, it is absolutely critical to understand the changes from the old law. So let's put Section 57 of the BSA side by side with its counterpart from the old Indian Evidence Act of 1872.
So in the past, this whole idea was covered under Section 62 of the Indian Evidence Act. Now, the core definition of primary evidence, that hasn't changed, but here is the massive difference, and this is what you absolutely must flag in your notes. Section 57 of the BSA now explicitly and in great detail incorporates electronic records through its new explanations. This is the single biggest evolution. It's what makes the law truly relevant for our modern digital age.
All right, let's boil all of this down into what matters most for you. What do you absolutely need to remember for your judiciary and APO exams? This is where we focus on the key takeaways. Okay, for your prelims, be on the lookout for a direct question. They might ask something like, which explanation of Section 57 deals with counterparts? For your mains, I would bet that a problem-based question on the admissibility of a video file or a temporary computer file is very likely. And definitely be prepared for a short note comparing the old Section 62 and the new Section 57. Your key focus has to be on knowing the gist of all 7 explanations.
For a quick final revision, lock these 3 things in your memory. First, the section number. It's Section 57. Second, the core concept. Primary evidence is the original document, which now explicitly includes electronic records. And third, its exam importance. It's very high, especially because of these new provisions on digital evidence.
And that wraps up our deep dive into Section 57. The key takeaway is really simple. The foundational rule of presenting the original hasn't changed, but its application has been totally revolutionized for the digital world we live in. This leaves us with a critical question for the future. As technology like AI and deepfakes gets more sophisticated, how will our courts adapt to determine what is truly primary and authentic evidence? Something to think about. For more content focused on your judiciary, APO, and law exams, make sure you stay connected with Ganga Education. Today, we're diving into Section 58 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about the concept of secondary evidence. And let me tell you, for anyone preparing for the judiciary and APO exams, this is one section you absolutely need to know inside and out.
So, here's our game plan for this explainer. We'll start with the core principles, then we're going to break down the 8 different categories of secondary evidence. After that, we'll look at some practical illustrations, discuss key case laws, compare the new act with the old one, and finally, I'll wrap things up with some solid exam tips to help you score those crucial marks.
All right, let's get started. To really understand Section 58, we first need to grasp the fundamental rule that it's actually an exception to.
You see, all evidence law really begins with one core idea, the best evidence rule. In simple terms, this just means that you have to present the best possible evidence to the court, and usually that means the original document itself.
So what does that really mean? Well, imagine you need to prove the terms of a contract. The court is going to ask for the original contract, right? Not a copy, and definitely not just someone's memory of it. The original is considered the most reliable, the gold standard. But here's a very practical question. What happens in real-life situations when the original document simply isn't available? Maybe it was lost in a fire, destroyed in a flood, or perhaps the other party has it and just won't produce it. Does that mean justice can't be served?
Of course not. And that's exactly where Section 58 of the Bharatiya Sakshya Adhiniyam comes into play. Think of it as the legal solution. It provides a list of substitutes, what we call secondary evidence, that the court can accept when the primary evidence is missing.
Okay, now let's get into the heart of the section. Section 58 neatly divides secondary evidence into 8 distinct categories. And this is a really comprehensive list, isn't it? It covers everything from official certified copies to copies made by mechanical processes and even oral accounts. The whole point is to make sure that even if the original is gone, there are still multiple ways to prove its contents.
From an exam perspective, these categories are super important. Let's focus on a few key ones. First, you have certified copies, like a sale deed issued by the registrar's office. This is very strong evidence. Then you have mechanical copies, like a photocopy or a scan. And then there's oral accounts. But remember, this is only valid if the person giving testimony has personally seen the original document. That's a key detail.
All right, understanding the law is one thing, but applying it is a whole different ballgame. To clear up any confusion, the Act itself provides some excellent illustrations. Let's break these down. According to Illustration A, a photograph of an original is perfectly valid. Now look at Illustration C. This one's a bit tricky. A copy made from another copy isn't valid unless that final copy was then compared with the original. And here's one for your prelims notes. Illustration D makes it clear that an oral account of a copy is not allowed. The witness must have seen the original. Now let's see how our courts have interpreted these rules over the years. For your mains answers, citing judicial precedents is absolutely essential.
On this topic, the most important case you need to know is H. Siddiqui versus R. Ramalingam. This is a landmark Supreme Court judgment from 2011 that lays down the foundational requirement for admitting secondary evidence.
So, what's the crucial point from this case? It's this. You can't just walk into court and present a photocopy. The Supreme Court held that the party who wants to introduce secondary evidence must first lay a foundation. You have to prove to the court why you can't bring the original. You need to give a valid reason for it being lost, destroyed, or otherwise unavailable.
This is the single most important takeaway from the case. For your exams, just remember this line. The foundation for the non-production of the original must be laid first. Only when the court is satisfied with your explanation will it even consider admitting the secondary evidence.
This whole principle can also be understood through a legal maxim. Verba volant, scripta manet. It means spoken words fly away, written words remain. And that's precisely why courts place so much emphasis on documents and have such strict rules for proving their contents. Now, I know a question on everyone's mind, especially those preparing under the new criminal laws, is what has changed from the old law? Let's clarify that right now. This provision was earlier under Section 63 of the Indian Evidence Act of 1872. Now it's under Section 58 of the BSA 2023. And here's the good news for students. The substantive law, the core principles, and those 8 categories, they haven't changed. It's primarily just a renumbering of the section. So whatever you've studied conceptually still holds true.
Okay, we've covered the concepts. Now, let's focus on how to convert this knowledge into actual marks in your exams.
For the judiciary prelims, you can expect direct MCQs from the 8 categories. They might ask what is or is not considered secondary evidence. For the mains, you could get a short note on the topic. But more importantly, you might get a problem-based question. If that happens, just remember the H. Siddiqui rule. Your very first step must always be to explain the reason for the non-production of the primary evidence.
All right, for a quick revision, just remember these 3 things. First, the section number is 58 of the BSA. Second, its core concept is to provide substitutes for an original document. And third, the key condition for its admissibility is explaining the absence of the original. This is, without a doubt, a high importance topic.
I hope this explainer has made the concept of secondary evidence crystal clear for you. For more judiciary, APO, and law exam-focused content like this, stay connected with Ganga Education.
Today, we're diving into a really important topic, Section 59 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is basically the bedrock of documentary evidence. It tells us how documents are supposed to be proven in court. And trust me, for your judiciary and APO exams, this section is absolutely crucial. So let's get right into it. All right, so here's how we're going to break it down today. First up, we'll introduce the main idea behind Section 59. Then, we'll actually decode the language of the BEAR Act itself. After that, we'll look at a practical example to see how this all works in a real courtroom. We'll also touch upon some key court rulings, and finally, we'll wrap it all up with the absolute must-knows for your exams. Okay, so let's start with our first topic, getting to know Section 59. We'll explore exactly why this rule is seen as the cornerstone of all documentary evidence in our legal system. So what's the big idea behind this section? Well, at its very core, it's all about something called the best evidence principle. It's a pretty straightforward concept, really. It just means that if you want to prove what a document says, the court wants to see the best possible evidence. And what's that? You guessed it, the original document itself. Now, for your judiciary and APO exams, you absolutely have to nail this principle down. It's that important. All right, let's move on to our next part. Here, we're going to take a closer look at the exact wording of the BEAR Act. It's super important to understand the language the law uses. The BEAR Act is actually pretty clear. It says documents shall be proved by primary evidence, except in the cases hereinafter mentioned. So, in simple terms, what does that mean? Well, the law is laying down a general rule. You must produce the original document in court. A photocopy or someone just talking about what the document said, that's usually not good enough. Unless, and this is a big unless, your situation falls into one of the specific exceptions mentioned later in the Act. For example, maybe the original is lost or the other side has it and won't produce it. So the section talks about primary evidence. But what does that actually mean? It's simple, really. Primary evidence is the original document itself, the actual piece of paper produced for the court to see with its own eyes. Think about it. The original signed contract, the original registered will, the original sale deed. These are considered the gold standard, the most reliable proof you can have. Okay, so this section really has three key ingredients. First, you need a document whose contents are in question. Second, the rule demands primary evidence, which means you have to produce the original. And third, this entire framework is built on the best evidence rule, the principle that requires the most reliable form of proof available. So, how does a court actually use this section in practice? Well, you can think of it as a logical three-step checklist. First, the judge asks, is the content of a document the main issue here? If the answer is yes, they move to step 2 and say, okay, show me the original. And by doing this, in step 3, the court is applying the best evidence rule, making sure its judgment is based on the most authentic proof possible. All right, all this theory is great, but let's see how it plays out in a real-life situation. We're going to look at a practical courtroom scenario to make this rule crystal clear. Okay, let's imagine a classic tenancy dispute. The tenant says the rent is 10,000 rupees, and to prove it, he shows the court the original signed rent agreement. But the landlord disagrees. He claims the rent is actually 15,000 rupees, and he brings a photocopy that shows that higher amount. So what does the court do? Well, following Section 59, the judge is going to prioritize the primary evidence. That means the original agreement from the tenant wins because it's simply the best and most trustworthy proof. Now, it's really important to remember that a law is just words on a page until courts apply it. So let's dive into how judges have interpreted Section 59. We'll look at some landmark cases and even a legal maxim that have really defined how this rule works. A really big case here is Roop Kumar versus Mohan Saidani. In this landmark judgment, the Supreme Court laid down a super important principle. They said that once you've written down the terms of a contract, that document is the only proof of those terms. You can't have someone come to court and give oral testimony to change, add, or subtract from what's written. Essentially, the document itself is the final word. Then we have the case of H. Siddiqui versus A. Ramalingam. Here, the Supreme Court clarified something really important about the exceptions. They said you can't just show up with a photocopy, which is secondary evidence, whenever you feel like it. No way. If you want to use secondary evidence, you first have to prove to the court that you've met all the strict legal conditions for doing so. You can't just skip the requirement for the original without a very good, legally valid reason. In building on that, we have J. Yashoda versus K. Shobarani. This case really spells out what laying the foundation means. The court said if you want to use secondary evidence, you have to prove two things first. One, that the original document actually existed.
And 2, you have to prove that the original has been lost, destroyed, or you can't get it for some other legally accepted reason. If you can't prove both of these things, the court won't even look at your secondary evidence.
You know, there's a classic Latin maxim that perfectly sums up the spirit of Section 59. It's verba volant, scripta manent. It means spoken words fly away, written words remain. And that's exactly why the law trusts a written document so much, right? It's permanent, you can check it, and it's a lot more reliable than someone's memory. Okay, we're heading into the final stretch. This is where we pull everything together and focus on exactly what you need to know for your exams. Let's lock in the key points about Section 59. Now, a very common question in exams is about the old law. So, listen up. This rule used to be Section 64 in the old Indian Evidence Act of 1872. Under the new Bharatiya Sakshya Adhiniyam 2023, it's now Section 59. The most important thing to remember, it's just a change in the number. The actual legal rule, the principle itself, hasn't changed at all.
Here's another key point to clear up. Section 59 doesn't come with any punishment. Why? Because it's what we call a rule of procedure. It's not defining a crime. It's just telling you how to present evidence in court. So you won't find any mention of jail time or fines attached to this section.
So, for your exams, here are my top tips. For prelims, be ready for direct questions. They'll ask you which section deals with the best evidence rule. The answer is Section 59. For mains, expect problem-based questions. They'll give you a scenario and you'll have to apply this rule. And a pro tip for your answers, always quote the landmark cases we just talked about. It makes your answer so much stronger. Okay, let's do a super quick revision. If you remember only 3 things about Section 59, let them be these. 1, the section number is 59 of the BSA 2023. 2, the main idea is that documents must be proved by primary evidence, the original. And 3, the underlying principle is the best evidence rule. And remember, its importance for both prelims and mains is extremely high. And that's a wrap on our deep dive into Section 59. I hope this breakdown has made things much clearer for you. For more legal content specifically designed for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
आज हम डिस्कस करेंगे Section 60 of the Bharatiya Sakshya Adhiniyam 2023. Now this section is absolutely crucial because it deals with a very fundamental question. When can you use a copy instead of an original document in court? For your judiciary and APO exams, this is a topic you simply cannot afford to miss. So, let's get right into it.
So to really understand why this section matters so much, let's think about a real-world problem. Just imagine, you have a case and the most important piece of evidence, say an original will, is completely destroyed in a fire. What happens then? Is the case just lost? Is there absolutely no way to prove what was in that will? Well, the law has an answer, and that answer is found right here in Section 60.
Okay, so here's our game plan for today. First, we'll cover the best evidence rule, the main principle. Then, we'll dive deep into the 7 exceptions to this rule. After that, we'll see how courts actually apply this in real life. We'll also quickly compare the new law with the old one. And finally, I'll give you an exam master plan to help you score those crucial marks.
All right, let's start with the basics. Before we can talk about the exceptions, we really need to understand the main rule, don't we? And when it comes to documents as evidence, the law has a very strong preference. This is what we call the best evidence rule. So what exactly is the best evidence? Well, the law calls it primary evidence. And in simple terms, that just means the original document itself. That's it. The court always wants to see the real deal. The original contract, the original will, you get the idea. It's like if you wanted to show someone a beautiful painting, you wouldn't just show them a photo, right? You'd show them the actual painting. That's the core principle here. But okay, what if you just can't produce the original? This is where secondary evidence comes into play. Think of it as the backup plan, the substitute. This could be a photocopy, a certified copy, or even someone's spoken testimony about what the document said. And this is where Section 60 is the hero of our story. It acts like a gatekeeper, telling us exactly when these substitutes are allowed into the courtroom.
All right, now we get to the heart of the matter, the 7 exceptions. This is the core of Section 60. It lays out 7 very specific situations where the best evidence rule gets a pass. And these exceptions are the exact legal solutions for problems like that destroyed will we talked about earlier.
Let's break these down one by one. First up, Clause A. This is when the original is with your opponent and they just won't give it up. Simple. Next, Clause B. This applies when your opponent has given a written admission about the document's contents. Then we have Clause C, our fire scenario, where the original is lost or destroyed.
Clause B is for things that are not easily movable. Think of an inscription on a huge building. Clause E deals with public documents, like government records. Clause F is for when a certified copy is specifically permitted by some other law. And finally, Clause G is for when you have numerous documents, like thousands of financial records, and it's just not practical to bring them all to court. Okay, now this next part is extremely important, so listen closely. It's not enough to know that you can give secondary evidence. You also have to know what kind of secondary evidence is allowed, and the law is very specific about this. For clauses A, C, and D, that's opponent lost/destroyed and not movable, you can use any type of secondary evidence, like a photocopy or even oral testimony. But, and this is a big but, for clauses E and F, the public documents, you can only use a certified copy. This distinction is a favorite for exam questions, so make sure you have it down.
So that's the theory. But how does this all play out in a real courtroom? Let's move from the books to the bench and see how a lawyer actually puts Section 60 into action.
Let's take a simple example. Imagine you're a lawyer for a tenant. Your client is suing their landlord over a rent agreement. Now, the original agreement is with the landlord, who's pretending it doesn't exist and won't produce it in court, even after you've sent a proper notice. What do? This is a textbook case for Section 60, Clause A. You can stand up in court, explain the situation, and then present your photocopy of the agreement as evidence. Since you've met the condition, the court can accept it. And this whole process perfectly illustrates a key principle from the landmark Supreme Court case H. Siddiqui versus A. Ramalingam. The court made it very clear. You can't just walk in and submit a photocopy. No, you have to lay the foundation first. What does that mean? It means you have to prove why you don't have the original. You have to show the court that one of those 7 conditions we talked about actually exists. Only then, once you've built that foundation, can your secondary evidence be considered.
Now, for those of you who have studied the Old Indian Evidence Act, you might be wondering how this all connects. Let's do a quick comparison between the old law and the new law.
It's actually very straightforward. What we know today as Section 60 in the BSA was previously Section 65 of the Indian Evidence Act of 1872. And the most important thing to remember is this: nothing has fundamentally changed. The substance, the principles, the 7 conditions, they are all exactly the same. It's basically just a renumbering. So all the case law and understanding you have for Section 65 now applies directly to Section 60.
Okay, let's switch gears and focus on what matters most for you, the exam. How do you take all this knowledge and turn it into marks? Let's build your exam master plan for this section.
For your prelims, you'll likely see direct questions. They might give you a small situation and ask if secondary evidence is allowed, or they might just test you on one of the clauses. For mains, be ready for 2 types of questions, either a straightforward short note on Section 60, or, more likely, a problem-based question where you have to apply these clauses to a story. So what's the key takeaway? You absolutely must remember those 7 conditions, and just as importantly, which type of evidence is allowed for each.
All right, time for a quick revision. Let's boil it all down. Point 1. The section is Section 60 of the BSA 2023. Point 2. The core concept is that it lists the exceptions to the best evidence rule. Point 3. The key principle is you can use secondary evidence in 7 specific situations. But remember the H. Siddiqui case. You must lay the foundation first. And finally, remember its exam importance is very high for both prelims and mains. Got it?
And that wraps up our deep dive into Section 60. As you can see, it's a beautifully balanced provision, ensuring we get the best evidence possible while also accounting for the real-world messes of litigation. For more such exam-focused legal content for your judiciary and APO prep, make sure you stay connected with us here at Ganga Education.
In today's explainer, we're diving deep into a really critical topic for your upcoming law exams, Section 61 of the brand new Bharatiya Sakshya Adhiniyam 2023. Trust me, understanding this section is absolutely essential for any question that touches on digital evidence.
So, here's what we've got on the agenda. We're going to start by introducing the section itself, then we'll decode its core concepts, and look at the all-important rule of admissibility. After that, we'll dive into some landmark case law, compare the new law with the old one, and finally, we'll wrap up with a sharp focus on what you need to know for your exams.
All right, let's kick things off. Think about it. Technology is everywhere in our daily lives, right? From emails and social media to our financial transactions, so much of what we do creates a digital trail. It's only natural that the law has to recognize the evidence coming from these platforms. And that's exactly what Section 61 does. It provides the legal foundation for it all. Okay, so let's get straight into it. We're talking about Section 61 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals specifically with the admissibility of electronic evidence. You're going to want to pay close attention because this is a super important section for both your judiciary and APO exams.
Now look at the language of the law itself. What does this really mean? Well, in simple terms, it means a court can't just throw out a piece of evidence simply because it's a digital file and not a physical piece of paper. This is a game changer because it gives electronic records proper legal standing right from the get-go.
Okay, so now that we have the basic idea, let's break it down further. To really get a handle on Section 61, we need to be crystal clear on the specific terms it uses. This is what helps us apply the law correctly in any given situation.
This section really boils down to three important elements. First, the electronic or digital record. That's basically any information that's created or stored electronically. Second is admissibility, which is just a legal term for whether a piece of evidence is even allowed in court. And third, and this is crucial, the concept of same legal effect. This means a digital document carries the same legal weight as its physical counterpart.
And to bring this into the real world, just think about the things you use every single day. The emails you send, those WhatsApp messages you exchange, digital photos on your phone, CCTV footage from a corner store, computer files, online banking records. Yep, all of these fall squarely under the definition of an electronic record. Now we're getting to the most critical part of this whole provision, especially for practical purposes. See, it's not enough for evidence just to be electronic. There are certain conditions it has to meet to actually be accepted by a court, and this is where its partner, Section 63, makes its grand entrance. So, this begs a really important question for any law student. Just because Section 61 exists, does that mean electronic evidence is always admissible? Well, the answer might surprise you. It's a firm no.
And this shows you exactly how it works. Think of it like this. Step 1. Section 61 opens the door, saying electronic records can be admitted. But Step 2 is the catch. It's all subject to Section 63. So the real clincher is Step 3. You absolutely must prove the authenticity and reliability of that record, following the rules laid out in Section 63. This usually means providing a certificate to verify the whole process.
You know, the law isn't just about what's written in the books, right? It's about how the courts, and especially the Supreme Court, have actually interpreted and applied it. So let's take a look at some of the landmark cases that have literally shaped the law on digital evidence in India.
The first, and arguably the most significant case you need to know in this area, is Anwar PV versus P.K. Bashir. This 2014 Supreme Court judgment completely changed the game when it comes to the admissibility of electronic evidence.
So the big question here was, how do we properly admit electronic records? The Supreme Court laid down the law and held that the certification requirement, which as we just saw is now in Section 63, is a mandatory precondition. The court's reasoning was simple. Digital evidence can be tampered with easily, so this certificate acts as a necessary safeguard.
So, a few years down the line, in 2020, the Supreme Court had to revisit this whole issue in the case of Arjun Panditrao Kotkar. The idea was to clarify some of the principles that were laid down back in the Anwar PV case.
The question this time was a bit more specific. Is there any exception to this mandatory certificate rule? The court said yes, the certificate is still mandatory, but, and this is a big but, they carved out one very logical exception. You don't need a certificate if you produce the original device itself in court for inspection. Makes sense, right?
Okay, now let's look at a case that really shows the practical impact of these rules, especially in a criminal trial. We're talking about the case of Tommaso Bruno versus the state of Uttar Pradesh.
In this case, the court really emphasized the importance of evidence like CCTV footage. It held that when this kind of evidence is properly authenticated, following the rules we've been discussing, it's not just some extra proof. It can be absolutely crucial in establishing the facts of a case. This just goes to show you the real-world power of Section 61. Now, for those of you who've already studied the old Indian Evidence Act of 1872, it's really important to understand how these rules have been carried over and, well, improved in the new law. Let's do a quick side-by-side comparison. So, under the old law, this was all covered in Sections 65A and 65B, which were actually added later through an amendment. In the new BSA, it's now explicitly recognized and neatly consolidated under Sections 61 to 63. This is a big structural improvement because it makes the whole legal framework much clearer and more up-to-date. All right, let's get to the final section. And honestly, this is probably the most important part for all you aspirants watching. How do you tackle this topic from an exam point of view?
So please, pay close attention here. For your judiciary and APO exams, understanding Section 61 isn't just about knowing the text of the law. It's about knowing how questions are likely to be framed from this topic.
In your prelims, you'll probably see a direct question like, which section of the BSA deals with admissibility of electronic records? Easy, Section 61. For your mains, a short note on this topic is a classic. But what you really need to be ready for is a problem-based question. They might give you a scenario with CCTV or WhatsApp evidence and ask you to decide if it's admissible. That's where you have to apply Section 61 together with Section 63.
So, to wrap everything up, let's do a super quick revision. There are 3 key things to lock in your memory. First, the section number, which is 61. Second, the core concept, which is the admissibility of electronic records. And third, its crucial connection to Section 63, which lays down the conditions. And remember, this topic is of very high importance for your exams.
We really hope this detailed explainer on Section 61 was helpful for your preparation. For more exam-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
You know, we often wonder, how exactly does something like a WhatsApp message or CCTV footage become solid, legally valid evidence in court? Well, that whole process kicks off with a really crucial new provision, Section 62 of the Bharatiya Sakshya Adhiniyam 2023. In this explainer, we're going to break down this brand new cornerstone for handling all kinds of electronic evidence.
So here's how we're going to tackle this. We've got it split into 5 key parts. We'll start with a basic introduction, and then we'll really decode what the section is all about. After that, we'll look at how it actually works in a courtroom, compare it to the old law, and then we'll rack up with some really important exam-focused tips and a super quick revision. So let's get right into it.
All right, let's dive in. We are talking about Section 62 of the Bharatiya Sakshya Adhiniyam 2023. Now, I want you to think of this section as the official gateway. It's the first step you absolutely have to take. It's the starting point for presenting any kind of electronic evidence in front of a judge. What this section does is it lays down the special rules for any evidence that's an electronic record. To put it simply, it sets up the fundamental rule for proving any piece of digital evidence. For both your judiciary and APO exams, believe me, understanding this section is absolutely critical. Now, the bare act itself sounds almost too simple. It just says the contents of electronic records may be proved in accordance with the provisions of Section 63. But what does that really mean? In plain English, it means that if you want to prove an electronic record in court, you must follow the specific procedure that's laid out in the very next section, Section 63. It's not a choice, it's a legal command. So, to really get a grip on this section's impact, what are the key ideas we need to understand? Let's break down its most essential parts. First things first, what exactly is an electronic record? Well, it's basically any information that is stored, sent, or created in a digital format. And we see this stuff everywhere, right? Emails, WhatsApp chats, that crucial CCTV footage from a crime scene, or even just regular computer files. All of these things fall under this legal umbrella of electronic records. Okay, so why do we even need this section? What's its purpose? Its main job is to create a standard, safe procedure for admitting digital evidence. And why is that so important? Because, let's be honest, digital data can be changed or faked pretty easily. This section is here to make absolutely sure that any digital evidence shown in court is the real deal, authentic and reliable. Now, this slide gets to the single most important thing you need to know about Section 62. It never works alone. It's what we call a link provision. Section 62 lays down the basic rule, and then it immediately points you over to Section 63 for the actual step-by-step procedure. So remember this, you always have to read Section 62 and 63 together. They're like two sides of the same coin. So we've got the theory down. Let's switch gears and look at the practical side of things. How do these rules actually get applied in the real world, inside a courtroom? It's a fair question, right? You might be wondering, okay, that's what the book says, but how does a lawyer actually use this section to get their digital evidence accepted by a judge? Let's picture a real-life scenario. Imagine a criminal case where the prosecution has some CCTV footage that clearly shows the accused committing the crime. Now, to get that footage admitted as evidence, the prosecutor first has to bring up Section 62. That section then acts like a signpost, directing them to follow the very strict procedure in Section 63, which, includes things like producing a certificate of authenticity. Now, you can't really understand this area of law without looking at what the courts have said. And there are a couple of landmark judgments you absolutely must know. The first one, and probably the most important, is the Supreme Court's decision in Anwar PV versus PK Bashir. In this game-changing case, what the Supreme Court wanted to do was set a very clear, non-negotiable standard. The court held that any piece of electronic evidence has to meet the requirements for authentication that are written right there in the Act. The big takeaway here is that these rules are mandatory, not optional. This is to stop the courts from getting flooded with unverified and maybe even fake digital evidence. But the story doesn't end there. The law was clarified even more in another huge case, Arjun Panchitrao Kakkar versus Kailash Kushanrao Garantil. This judgment really helps sort out some of the practical issues that came up after the Anwar PV decision. So, the most crucial point from this case is that the certificate for electronic evidence is, yes, absolutely mandatory. But there is one single exception. The court said that if the original device itself, like the actual mobile phone or the laptop where the data came from, is brought into the courtroom, then you don't need a separate certificate. Why? Because the court can then just look at the primary source of the evidence directly. Okay, so let's quickly look at how this whole thing has changed. How is the new Bharatiya Sakshya Adhiniyam different from the old Indian Evidence Act of 1872 on this point? Under the old Indian Evidence Act, you'd find these rules in sections 65A and 65B. Now, under the new Bharatiya Sakshya Adhiniyam, the main legal idea is still the same, but they've been tidied up and consolidated into sections 61, 62, and 63. This just makes the whole structure a lot more organized and easier to follow.
All right, let's get to the final, and I think most important, part for all of you who are studying for your exams. Let's focus on exactly what you need to know, and then we'll do a quick revision.
Now, listen up. For your judiciary prelims, it's very likely you'll get a direct question. Something like, which section is the gateway for proving electronic records? For the mains exam, you can probably expect a short note on this topic, or maybe a problem-based question involving a situation with CCTV, call records, or email evidence. Okay, time for a super quick recap. If you don't remember anything else, just lock in these three things. First, the section number. It's 62. Second, the core concept. It's a link provision that points you to section 63 for the actual procedure. And third, its exam importance. No question about it, it's high. And that brings us to the end of our explainer on section 62 of the Bharatiya Sakshya Adhiniyam. For more legal content focused on judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Today, we're diving into a really crucial topic, something that's super relevant in our digital world, the admissibility of electronic evidence. Let's kick things off with a question that I'm sure many of you have thought about. Can your WhatsApp chats, or maybe some CCTV footage, actually be used as evidence in a court of law? Well, the answer is a big yes, but there's a catch. They have to meet some very specific legal conditions. So let's explore exactly how the law handles this.
So, today we're going to discuss Section 63 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about the admissibility of electronic records as evidence. And let me tell you, for anyone preparing for judiciary and APO exams, this section is extremely important, so make sure you're paying close attention.
All right, let's break down the bare act and get to the core principle. In simple language, what this section says is that any information inside an electronic record, think of a printout or a file on your computer, is legally considered a document. Now, what does that mean? It means a copy of that record can be admitted in court as evidence, and you don't even have to produce the original device if, and this is a big if, the conditions laid out in this section are met.
So, what exactly does the law mean when it says computer output? It's actually a pretty broad term. It's not just about a simple printout from your printer. We're talking about printouts of emails, screenshots of your messages, those crucial CCTV recordings, digital photographs, call detail records, and yep, even data that's stored on a USB drive.
Okay, here's the most crucial part to understand. Just because something is an electronic record doesn't mean it's automatically admissible in court. Nope, the law is very careful here. It sets out specific conditions to make sure the evidence is authentic and hasn't been tampered with. Let's call them the 4 pillars of electronic evidence. Let's see what they are.
So, subsection 2 gives us 4 conditions. And listen carefully, these are mandatory. First, regular use. This means the computer or device had to be used regularly for storing or processing information. Second is ordinary course. The information must have been fed into the system as part of normal, everyday activities.
Third, proper operation. The device has to be working correctly at the time the information was created. And finally, number 4, accurate reproduction. This means the output, like the printout, must be an exact copy of the information that was originally fed into the device. You see, all 4 of these conditions work together to guarantee that the evidence is reliable.
And the law is smart. It keeps up with modern technology. Think about how we work today, with networks, the cloud, multiple devices all linked together. Well, subsection 3 addresses this. It clarifies that if information is processed through a whole network of computers, all of those devices are treated as a single computer system for the purpose of this section. It's a very practical and forward-thinking provision, right?
Okay, let's pause here, because we are now at the single most critical procedural requirement of this entire section. I can't stress this enough. Without this one thing, your electronic evidence is almost guaranteed to be thrown out of court. We're talking about the mandatory certificate required under subsection 4.
So what is this certificate? Well, think of it as a signed statement, a formal declaration. It has to do a few key things. It must identify the specific electronic record, describe the process of how it was produced, give details about the device that was used, and, this is the most important part, it must confirm that all 4 conditions from subsection 2 have been met. And this isn't something just anyone can sign. It has to be signed by a person in a responsible official position in relation to the device.
Now, this certificate isn't just a procedural hurdle. Its importance has been stamped and sealed by the Supreme Court itself, time and again. We're going to look at 2 landmark judgments now. If you're a law student or a judiciary aspirant, you absolutely must know these cases to understand the law here. First up, we have the case of Anwar PV versus PK Bashir. This is the big one. Here, the Supreme Court laid down the law crystal clear. It held that the certificate we've been talking about is not just some formality you can skip. No, it is a mandatory prerequisite. The court's message was simple: no certificate, no admissibility. Period.
Then, the rule was clarified and strengthened even further in the case of Arjun Panditrao Kotkar. Now, this case reaffirmed everything said in Anwar PV. It basically said, yes, the certificate is absolutely mandatory in all cases, but it carved out one and only one exception. And what is that exception? It's when the original device itself, the phone, the computer, the CCTV system, is produced right there in court for inspection.
All right, let's shift gears and focus squarely on what this means for your exams. This section, believe me, is a favorite for examiners, which makes it absolutely critical for your preparation.
First things first, let's do a quick comparison with the old law. You might remember this provision as Section 65B of the Indian Evidence Act of 1872. Well, under the new Bharatiya Sakshya Adhiniyam 2023, it has moved. It is now Section 63. The core principles haven't changed. They are still the same, but it's vital that you use the correct updated section number in your exam answers.
So let's talk exam strategy. For your prelims, you can expect direct, straightforward questions. They'll ask about the section number or the mandatory nature of the certificate. But for the mains, get ready for a problem-based question. You'll likely see a scenario involving CCTV footage or WhatsApp chats. And when you do, your answer must include a few things. Mention Section 63, list out its 4 conditions, hammer home the point about the mandatory certificate, and of course, cite both the Anwar PV and Arjun Panditrao cases. That's how you score full marks.
All right, time for a quick revision. To wrap everything up, there are 3 key takeaways you absolutely need to remember. First, the section number, Section 63 of the BSA 2023. Second, the core concept. It's what makes electronic records admissible as documents in court. And third, the key requirement, that certificate under subsection 4 is absolutely mandatory.
And that brings us to the end of our discussion on Section 63. I really hope this detailed explainer helps you in your exam preparation. For more high-quality legal content all focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're diving deep into Section 64 of the Bharatiya Sakshya Adhiniyam 2023. This section covers a very practical and important part of evidence law called the notice to produce. You know, this is one of those topics that frequently comes up in judiciary and APO exams, so let's get right to it.
So I want you to imagine a situation. You're in court fighting a case, and the single most important piece of evidence, the original document, isn't with you. It's actually with the other side, your opponent. So how do you prove what's in that document? Well, Section 64 gives us the exact legal playbook for this very common problem.
All right, so here's our plan for today. We'll start by understanding what Section 64 is all about. Then we'll break down its core rule. After that, we'll look at the really important exceptions, when you don't need to give notice. We'll also see how this works in a real courtroom with examples and case law, compare the old and new laws, and then wrap it all up with a quick revision for your exams.
Okay, let's start at the very beginning. What is the big idea behind Section 64? Well, at its core, it's all about procedural fairness. The whole point is to make sure that no one gets ambushed with surprise evidence during a trial. It's designed to push parties to bring the best possible evidence, which is almost always the original document, to the court.
You see, in evidence law, we have what's called the best evidence rule. It's a simple golden rule. You must prove a document using its primary evidence, meaning the original document itself. But this leads to a huge practical problem, right? What happens when you don't have the original and you know for a fact that your opponent does? That's the exact gap that Section 64 is designed to fill.
Now, this is the key line right from the BEAR Act. It sounds a bit technical, doesn't it? But in simple words, all it's saying is this. If your opponent has the original document, you can't just walk into court and show a photocopy. No. Before you can use your copy, what the law calls secondary evidence, you must first give your opponent a formal written notice, basically a legal request, telling them to bring that original document to court.
So let's dig into the procedure a little bit. Think of Section 64 as a gatekeeper. It sets up a mandatory first step, a prerequisite that you absolutely have to follow. If you don't follow this step, the gate to getting your secondary evidence admitted by the court will remain closed. It's that simple.
And before we move on, let's just quickly get our terms straight. What exactly is secondary evidence? Well, under Section 60 of the Act, it's basically a substitute for the original. Think of things like certified copies or photocopies made from the original. It's the backup evidence you use only when the primary evidence, the original, is genuinely unavailable.
So if we break this section down, there are really three key ingredients. First is possession of opposite party. You have to show the court that yes, the original is with them. Second is the notice to produce, that formal legal request we talked about. And third, and this is the crucial part, is admissibility. It is only when they get your notice and still fail to produce the document that the court might let you use your copy.
So the whole procedure is actually very logical. Step 1. Establish that the opponent has the original. Step 2. Serve them a proper, formal notice to bring it to court. And then, Step 3. If, and only if they don't bring it, you can then go to the court and say, Your Honor, they're not producing it. Please allow me to present my copy.
Okay, but the law always tries to be practical. Section 64 has a very important proviso, which lists some specific situations where you actually don't need to give this notice. Now, for your prelims exams, let me tell you, these exceptions are pure gold. They are tested all the time.
There are 6 exceptions here, and each one makes perfect sense. First, if the document you need to prove is itself a notice. I mean, it would be silly to give a notice for a notice, right? Second, when the very nature of the case makes it obvious that the opponent will need that document. Third, if the opponent got the original through fraud or force. The law won't make you help a wrongdoer. Fourth, when the original is already with the court. Fifth, if your opponent themselves have admitted that the original is lost. And finally, sixth, when the person holding the document is outside the court's jurisdiction and can't be compelled to appear.
All right, enough of the theory. Let's bring this into the real world. Let's see how this section actually works in a courtroom and, just as importantly, how the Supreme Court has interpreted it over the years.
Let's take a very common civil case. A landlord sues his tenant for breaching the rent agreement. Now, typically, the original signed agreement is with the tenant. In this scenario, before the landlord can use his photocopy of the agreement as evidence, it is absolutely mandatory for him to first send a legal notice to the tenant asking him to produce the original in court.
And the judiciary has been very clear on this. 2 landmark cases really drive the point home. In H. Siddiqui versus A. Ramalingam, the Supreme Court said you must lay a proper foundation before secondary evidence can be allowed, and giving this notice is a key part of that foundation. Similarly, in J. Yashoda versus K. Shobarani, the court stressed that it has to be satisfied that you've taken all reasonable steps to get the original first.
Now, a question that I'm sure is on many of your minds is, what's changed from the old law? Is this a new concept? Let's clear that up right now.
The same exact rule used to be under Section 66 of the old Indian Evidence Act of 1872. Now, under the new law, it's Section 64 of the Bharatiya Sakshya Adhiniyam, 2023. So the key takeaway here is that there's no real change in the law itself. The substance is the same. It's just a renumbering of the section.
And now, let's get to the part you've been waiting for: how to approach this for your exams. Here's exactly what you need to focus on for Judiciary and APO.
For your prelims, be prepared for direct questions. They might ask for the section number, which is 64, and they absolutely love asking about those 6 exceptions. For the mains exam, it gets a bit trickier. You'll likely see a problem-based question, a story, where you have to apply this rule and its exceptions. And a pro tip, if you can quote a landmark case like H. Siddiqui in your answer, it will definitely make your answer stand out.
So, for a last-minute quick revision, just lock these 3 things in your mind. First, the section number is 64. Second, the core concept is simple. You must give notice before using secondary evidence. And third, the key takeaway is that those 6 exceptions are absolutely vital. Know them by heart. And this brings us to a final thought, something for you to chew on. How can a clever lawyer use the exceptions in Section 64 strategically in a trial? Maybe to get evidence in quickly or to put the other side on the back foot. Think about it, because knowing the law is one thing, but knowing how to use it is what makes a great advocate.
For more such deep dives into legal topics for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're diving deep into Section 65 of the new Bharatiya Sakshya Adhiniyam 2023. This section is all about proving signatures and handwriting. And let me tell you, it's an absolutely crucial topic for your judiciary and APO exams. So let's get right into it.
So, here's our game plan for today. We'll start with a basic introduction to Section 65, and then we'll really break down what the rule says. After that, we'll look at the different ways you can actually prove handwriting in court, touch upon some landmark cases, compare it with the old law, and finally, wrap up with some key revision points specifically for your exams.
All right, let's start with the fundamentals. Section 65 is, you could say, the bedrock when it comes to documentary evidence. Its main job is to set up a clear process for making sure that any document brought before a court is actually authentic.
Now, you might be wondering, why is this one section so important? Well, think of it as the gatekeeper of the courtroom. It's a vital safeguard that protects the entire judicial process from being derailed by fraud, forgeries, or any kind of fake documents.
Okay, to really understand the power of this section, we need to look at the exact legal language. This is where we see what the law actually commands us to do.
The BEAR Act puts it like this, and this is really the heart of the matter. If a document is alleged to be signed or to have been written by any person, the signature, or the handwriting, must be proved to be in his handwriting. That line right there, that's the core legal command of this entire section.
So what does all that legal jargon actually mean in simple terms? It's pretty straightforward. It means that just showing up in court with a document isn't good enough. If you're the one presenting that document, the responsibility, the burden of proof, is on you to prove that the signature or the writing on it is genuine. Let's just zoom in on 2 crucial phrases from that rule. First, when the law says alleged to be signed or written, that simply means a claim is being made about who created the document. But the second part, the phrase must be proved, well, that's the real powerhouse. It clearly states that the legal duty to prove it's real lies with the person who brought the document to court.
Okay, so the law says you have to prove it. The next logical question is, how do you actually do that in a courtroom? Thankfully, the law recognizes several established methods for proving a signature is authentic. Let's take a look.
There are 5 main ways to do this. First, you have eyewitness testimony, someone who literally saw the pen hit the paper. That's direct evidence. Second, you can bring in someone who is acquainted with the handwriting, maybe a close colleague or a family member who sees it all the time. Third, there's the opinion of a handwriting expert, though it's important to know this is usually used to support other evidence. Fourth, the judge can do it themselves. The court can compare the signature in question with another one that is known to be genuine. And finally, the simplest method of all, an admission from the person who supposedly signed it.
Now, let's shift gears and talk about case law. For your mains exam, just knowing the section isn't enough. You have to understand how the Supreme Court has interpreted and applied this rule in real-life situations. We're going to look at 2 really pivotal judgments that have helped shape our understanding of this provision. And just as a quick reference point, remember that this was earlier known as Section 67 under the old Indian Evidence Act.
First up, we have the landmark case of Murari Law versus the state of Madhya Pradesh. The big question here was, how much weight should a court give to a handwriting expert's opinion? The Supreme Court made it very clear.
It held that an expert's opinion is relevant and important, but it's not conclusive. It doesn't automatically bind the court. The judge must always apply their own mind and carefully weigh that opinion against all the other evidence on record.
Then we have the case of Ram Narayan versus the state of Uttar Pradesh. This case really hammers home the core principle of Section 65. The court essentially said, look, you can't just assert that a document is genuine and expect us to believe it. It must be proved with solid, reliable evidence. Mere claims just won't cut it. Let's take a quick but important look at how this provision fits in with the old law. It's always useful to know the history and the corresponding section number for your reference. So this provision isn't brand new. Under the old Indian Evidence Act of 1872, this same rule was found in Section 67. Now, under the new Bharatiya Sakshya Adhiniyam of 2023, it has simply been renumbered to Section 65. The legal principle, the substance of the rule, remains exactly the same.
Okay, now for what you've all been waiting for. Let's get down to brass tacks. How will this topic appear on your exams and what you absolutely need to know?
For your prelims, you can expect a direct question about the section number, that's Section 65, and its main purpose. For the means exam, however, be ready for a problem-based question. They might give you a scenario with a disputed will or a contested contract and ask you to apply the law. And here's a pro tip. Whenever you write about expert evidence in your answer, you absolutely have to mention the Marari Law case. It will make your answer stand out. So, for a quick final revision, let's lock in 3 key points. First, the section number is 65 of the BSA 2023. Second, the core concept is simple. A signature or handwriting must be proved. And third, its importance for your exams, especially for the mains paper, is very, very high. And that wraps up our detailed explanation on Section 65. I really hope this structured breakdown has been helpful for your exam preparation. For more legal content focused specifically on judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.